Good evening. This is Laws 11057, Introduction to Law. We're into week 7. Initially, we're going to cover some of the material that we should have covered in week 6, and that is in particular in relation to being ethical, chapter 13 in the text. Now, our guest tonight is Michael Baker, who's going to show us some of the intricacies of dealing with LexisNexis. So, Michael, if I could hand over to you. Thank you.
Okay. Thanks, John. Hi, everyone. Okay, I'll just I'll start from the university library database. This is the way I just go about getting in. I'm just going to go here to LexisNexis AU and log in. No, I was on there obviously a bit earlier this afternoon, so it's come up straight up to the home page. And just as some preliminary comments, I found that this website acts as a reasonably good supplement to OSLI. And also, I think the best function of this website is its encyclopedia function, the Halsbury's Laws of Australia. I've found to be very good, so I thought I'd spend a bit of time looking at that function. But just on the home page, there's sort of 3 areas, I guess. There's the tabs across the top, which I was going to go through. Then there's this quick find function where you can search by case name, you can search by keyword, by legislation, by title. And over here on the right, you can. There's a shortcut to search. Again, you could search legislation. You can search cases. You can search for definitions in the dictionary. You can search for through the encyclopedia over here at Halsbury's Laws of Australia. But what I was just going to do was, first of all, just look at this general tab, and if I just wanted to find some information generally, say, for example, I was wanting to know a bit more about Mabo, I'd type in Mabo and I can do 2 things. I can click on this sources button here and say all subscribed sources, or I can modify my search and just choose any one of these. I'm just going to search all of them. So I'll search for information on Mabo, and it throws up 173 search results. Now, what I might want to do then is I might want to narrow the search. I just want to know some general information about Mabo, and I might want to look at, say, some information coming out of the legal dictionary on Mabo. So on the left-hand side is where you can narrow the search down. And then I might want to say, well, okay, I might sort this by relevancy. There's a button here. You can either sort it by sources or by relevance. So if I click on relevance, you can see that there's a number of results have come up, and this top one will explain what Mabo is, and it's I can click on Mabo and it will bring up some information about it. And you can see there it explains it was the 1992 decision of the High Court, et cetera, and it goes through a brief description about Mabo. It also gives you some key catchwords below: Aboriginal land rights, Crown land, native title, terra nullius. So that sort of gives you a bit of information about Mabo. But then I see down here there's some information on terra nullius, and what I might do is just I might be interested in reading about what terra nullius is. And you can see, given it's coming out of the dictionary, it provides you with a definition of what terra nullius is. And so that sort of is a way of drilling down into a particular area that might be of interest to you. There's also a handy function over here on the right-hand side. You can preview what I just looked at, and if I do that now, you can see that it pops up to the right, and all the search results are still on your page, which is, I find that reasonably handy. The other button here is delivery folder. So if you wanted to use this information later on in your session, you can just click on delivery folder, and that will add it up here, up to the top of the screen here. You'll see what that does is it allows you to print, download, or email that particular search result later on in your session. So you can build up a folder of information as you go, which is pretty useful. The next area I was going to look at is just the let's see, is the cases tab. So here you can see that the cases tab, it allows you to search obviously for particular cases. Now, the majority of cases here give you a brief rundown of the case and a summary of the judgment, but not all the time. Sometimes it just gives you some catchwords. So there's two ways I've gone about looking for a case. Now, say for example, I want to find a recent case potentially involving, say, contract law. You can either go through this search button, or you can browse by category. Now, browse by category is browsing by the area of law. So say I want to look for a recent case. I go down here to 2014. I'll go into the latest issue. And down here, it'll show you all the different areas of law that has cases recently. And down here towards the bottom of this screen is contract. So I'll click on contract, and I might want to look at a Commonwealth case. I click on Commonwealth, and you can see there's a case here that's come up, Stratton Finance and Webb. So I might want to just have a look at that. And you can see what it does. All it's given me is a little bit of information. It's given me the catchwords, breach of contract, underpayment of commission damages, and employment. So it just, not all of them will give you a synopsis of the judgment, but some of them do. So what that then does is I say, well, okay, maybe I want to look at cases involving breach of contract and potentially maybe, say, employment. So what I can do is go back to the search button, and in the catchwords, I'll type in breach of contract and employment. And then what I'll do is I'll say, well, I want to look at the Commonwealth jurisdiction, and then I'll search. And what that does is it throws up all the cases that have the catchwords breach of contract and employment in the catchwords of the case. So you can see here there's the one that I was looking at earlier, Stratton Finance and Webb, and then there's obviously all the others down here. And again, you can drill into these and have a look at any ones you want, and potentially again, you can put those into your delivery folder. So the other way I was going to look at a case was, again, back to the search function. Say I know the case name. So I know I looked at a case earlier called Mills and Meeking. So if I type that in, you can see it drops down and it will start searching for the case. There it is there. So maybe I want to look at this case and see maybe what other cases were of similar, had some similar sort of information in it. So I go Mills and Meeking, again, Commonwealth jurisdiction. And here it gives you, like I said, it gives you a synopsis of the case and a brief summary of the judgment. It also gives you the catchwords that they use for the case. So in this case, the two that are of interest to me are offences and motor vehicles. So maybe I want to look at similar cases that involve offences and motor vehicles. So what I'll do again is go down to the catchwords and put in motor vehicles and offences and search that. And then it will throw up 22 cases that have those catchwords in them. And again, I can sort by relevancy over here on the left-hand side. You can sort by topic, but I might just want to search by relevance. And you can see the case that I was looking at, Mills and Meeking, is here, and then all the others down here. So that's a bit on cases. Just on legislation, I found this area not as helpful, partly because I think the level of subscription that we have doesn't lend itself to accessing much. But I'll just briefly show you. You might want to look at potentially know of what other acts have been affected by the passing of a new act. So say, for example, I'd go into the Australian current law legislation on the left-hand side. And I know I've looked at this earlier today, but you can say you know what the act is. And in this case, I know the act is the Crimes Amendment Act of 2005. I want to search within all the other acts that have been passed and in the Commonwealth jurisdiction. And so this will throw up all the other acts that have been affected by the passing of this act. You can see down here at the bottom, it says other acts affected by Act number 96 of 2005. And so there's two acts here, the Crimes Act and the Telecommunications Act of 1979. So that's just an area where if you were interested to know that, that may be of some use. But really, for me, the most important or the best function of this website is the next part, which is accessing Hallsbury's Laws of Australia. And I've used this because currently in contract law we've got an assignment on the postal acceptance rule. And what I thought I'd do is just quickly show you how you can, how I access information on that rule. So what all it does is, it's just, as I said, it's an encyclopedia. It's just like another textbook, really, that gives you information about the principles of the law, and it gets updated quite regularly. So it's quite useful. So if I want to go, I might go to there's two ways of searching. You can use the search function over here on the left, or you can use the browse function. I'm going to use this browse function, and I want to search for all this information in Hallsbury's Laws of Australia. Now, what it throws up is Hallsbury's have over 80 titles, and they're listed by number here. Well, the number corresponds to a particular area of law. So that's just used for cross-referencing and updating. But I'll go down until I find contract, and you can see number 110 relates to contract. Now, the postal rule I know, so you can expand that out. I know the postal rule relates to formation of contracts, so I'll expand that out, and you can see it's a hierarchical formation. I then go and I can say, well, I know the postal rule applies to offer and acceptance. It relates to the communication of acceptance. And there it is. You can see under communication of acceptance, there's the general rules and the postal acceptance rule. Now, within that postal acceptance rule, you can even expand that out if you want and hit that button. And it's got operation of rule and impact and scope of rule. But I might just want to have a look at the operation of the rule. And there you go. It throws up in paragraph 415 under the title 110, and the 110 again relates to contract law. It explains what the postal rule is. And then you can keep going down and you can see the next paragraph. Sorry, by the way, it also cites cases as well. So for example, in the postal rule, it gives you the authority, the case authority sitting behind the rule, and it gives you all the other cites all the other case authorities as well. And then the next paragraph goes on and you can see over here on the left-hand side, it lists the various paragraphs. So paragraph 420, when the rule applies, etc., etc. So I found it quite handy. It's a useful tool to search anything really about Australian law. Really, you can find in this encyclopedia. And as I say, it also provides you with cases as well, which is quite handy. What else? The other way I can search it is, or search a topic in law, is I can go up to this icon, explore by topic. Now, again, I might want to look at contract law, and I'm interested in learning about minors and whether minors actually have the capacity to contract. So if I look down at contract law, it says I can expand all. So I'll hit that button. And I know that I'll be looking at something called capacity to contract. Or capacity of parties. So here it is here, formation of contract, capacity of parties. I'm interested in looking at that. So what I'll do is I'll click on that, and over on the right-hand side, you can see that pops into this box here. And then you can decide, well, what sort of source type do you want to include to search for that information. I'm going to click commentary, and I'm going to search. And what it does is it's thrown up 59 search results. Now, I'd like to narrow that down because I'd like to know specifically about minors. So what I'll do is I'll narrow the search in the left-hand side, type in the word minors, and what that will do is it'll reduce that 59 search results down. So now I've got 23 results that have information on minors and capacity to contract. I may want to sort it by relevancy, and I'll do it. And I may, for example, want to look at some definitions about actually what is a minor. I'm not sure what a minor is. Okay, here's some information here. Infant, and you can see that a minor is a person who has not attained the age of majority. And it goes on to explain some information about minors under contract law, under family law, etc. So it's quite a useful tool, and I found it to be reasonably helpful just in searching for various facts about the law. And just lastly, if we go back to the homepage. The other area is dictionaries, and that's helpful if you just want to search a definition of a term. And again, if we go back to the start, I might want to look at the definition of terra nullis. I can simply search that through this function. And again, I sort by relevance, and you can see that the top one is the definition of terra nullis. So that's pretty much it. That's all I really wanted to show everyone. I just say I found this useful as a bit of a complement to Osley, and the best part I've found has been the like I say, is the Hallsbury's laws. So if anyone's got any questions, feel free to ask, and I hope you found that useful.
That's excellent. Michael, thank you very much. I really appreciate it. Now, are there any questions? I'm looking at the chat facility. There's none there. Does anyone have any questions of Michael? That was a very good presentation. Thank you. Has anyone got any comments about the way they go about doing their research through LexisNexis? A couple of comments.
I'd just like to actually reiterate what a lot of people were saying on the chat at the moment, to thank Michael for the presentation. It was excellent. I'd also like to say I also found the dictionaries on LexisNexis excellent for looking up the definitions and finding related information. And I didn't know about the commentary, so I'm going to have to explore that now. Thanks, Michael.
No worries.
All right. No further comments. I think what you've done is create some interest, Michael, in some of your fellow students, and I'm sure they're going to now play around with LexisNexis at some length over the next couple of weeks. So we really appreciate that, and thank you very much.
No worries, Sean.
Thanks, Michael. Well, we might take the opportunity now to move on to Chapter 13 of The New Lawyer, dealing with ethical issues. And on Moodle and also UCrew, I gave some indication as to the areas that I want you to consider and read. I've only just uploaded onto UCrew the Australian Solicitors Conduct Rules, so there's something for you to look at. I assume that many of you would have sourced that already in any event. And in addition to that, we have the Barristers Conduct Rules. So the Australian Solicitors Conduct Rules, as at 1st of June 2012, can now be viewed on UCrew. There are some rules that I particularly want you to be aware of and consider as part of the work that you'll be doing in your studies. So the basic rule, I guess, is rule number 3 of the ASCR, and that is that a solicitor's duty to the court in the administration of justice is paramount and prevails to the extent of inconsistency with any other duty. Now, it's all very well saying these things, but when we're asked to consider them in practice, it's somewhat of a different thing. I'll refer you to a case of the Legal Services Commissioner against Douglas John Winning. It's from 2008. It's LPT. I'll see if I can upload this. It's a very interesting case in terms of what Doug Winning did, which was presented to the court, and some of the decisions which relate to the conduct are most interesting. So I'll upload that for your consideration. And what it really does is highlight the difficulty in trying to determine what we mean by the administration of justice. Now, I suppose many of you might think that your role as a solicitor is to the client above all else, but that's not the case. So certainly you have fundamental rules to act in the best interest of the client, but that's subject to that overriding rule in Rule 3 about the administration of justice. So sometimes it may be that your client wants you to act in a way which is contrary to the administration of justice, and you simply can't do it. It may mean that you have to withdraw or you may need to present your case in a way that does not breach that fundamental rule. In addition to that, you need always to be honest and courteous in your dealings in the course of legal practice. So if you read the winning case, you'll see some comments there that might be of surprise to you. In terms of advocacy and litigation, I've highlighted rules 17 to 29. In relation to clients, it's rules 7 through 16, and that includes the obligations in rule 8.1 to follow the client's lawful, proper, and competent instructions. And again, it's all very easy, but when we start to consider different circumstances, it makes it more difficult to perhaps apply in practice. So if a client, for example, provides you with certain instructions that might be lawful, might be proper, might be competent, but you know that the client is very emotionally involved, emotionally upset, and likely to regret the instructions, what do you do? So given that you've got an obligation to represent the client in the best way that you can, sometimes you need to be reasonably firm with the client, and that is to talk about the way in which the client might think about their actions and maybe come back to you the next day or two. And I see there's some comments in relation to the winning case about warning the bikies, and that was part of it, Erin. Yes. Thank you for that. All right. Now, in relation to advocacy, I've mentioned rules 17 to 29. You have certain responsibilities to the court. As a lawyer, you are in fact an officer of the court, and that has a special meaning. It means that you have special obligations, but you also have special rights as well. So you are afforded certain courtesies as a lawyer that you might not otherwise have, but it comes at a cost. So you are required to appropriately advance the client's case in a robust way, but in doing so, you're not to harass or embarrass a person. So there have been cases in the past where solicitors or barristers have been taken to task in terms of the way in which they go about cross-examining children, for example. And the rules have changed over the past 10 or 15 years in light of that. Now we have special rules that relate to protected witnesses, and special rules might mean that, for example, those witnesses who are children give their evidence not live to the jury, but it's pre-recorded. And it might be pre-recorded in circumstances where the child is in a separate room to where the judge and the legal counsel are from. So it might be just in the next room, but the child won't see the defendant and will only see the barristers or the solicitors and the judge through a video camera. So they're all special rules that came into effect to guard against what was perceived as bordering on harassment in relation to the matter of children. And they're rules that can be looked at in the Evidence Act. And your actions need to be reasonably justified and appropriate for the advancement of the case. So it is entirely possible that you'll be pulled up and hauled over the coals, as it were, if you act in a way which is not going to reasonably advance the client's case. All right, so for barristers, we have very similar rules. I'd ask you to look at the Bar Association of Queensland website. Many of you may have done that already. Can I just have a quick wave if you've had a look at the Bar Association website? Yes, so we're able to find it, okay. I will indicate that I'm very keen for you to read the Solicitor's Conduct Rules, and I'm keen for you to read the Barrister's Rules as well. So I've identified what I believe are the important ones. This is all examinable. I want you to know something about the ethical rules that relate to the way in which barristers go about their practice primarily in a courtroom context. Are there any questions so far in terms of the issue of ethics and the Australian Solicitors' Conduct Rules and the Bar Association rules? Nothing on the chat facility? Yes.
Rule 20.1, so did I understand it correctly? Even though as a solicitor you know that your client has lied to the court, you can't tell the court until authorised by your client. Is that right?
If your client has lied to the court, is that what you said, Maria?
Yeah, 20.1, it says if you learn during a hearing that your client has lied to the court, falsified a document, you must promptly inform the court of the lie, only if you're authorised by the client, but otherwise you may not inform the court of the lie.
And this is a very difficult area because if you're in the middle of a trial, it may be difficult to withdraw without prejudice to the client. What you certainly can't do is advance anything which is inaccurate in any way. Sometimes you're required, in fact, to remain mute. Say, for example, a prosecutor stands up and says in relation to your client that your client has no criminal history, and you know that's not the case. You're not obliged to correct what the barrister, the prosecutor has said, but you can't then positively assert to the court that your client does not have a criminal history. So there's a fine line, Maria, sometimes between what you are required to do in terms of saying nothing and what you must not do in terms of advancing something which you know to be incorrect. And you certainly can't do anything to mislead the court. So there are fine lines, and thank you for reading that carefully, and I'd ask that you all read those rules very carefully because they are important. There are some rules that relate to conflict between professional and personal ethics, and some good commentary in the textbook. There's the distinction between the traditional view, the alternate view of responsible lawyering, and what Parker and Evans describe as an ethic of care over all other approaches, adopting a more holistic approach. So I'd ask you to read that carefully and have some idea of how you can describe that if it was to be found in an exam situation. I'm going to ask you generally to read, for interest, parts of the commentary from pages 435 through to 455. That's more for interest and content or context. But when we get beyond that, from page 456 onwards, we have some more meaty parts. And that deals with professional ethics, and that's where I'd like you to concentrate in your reading in that particular chapter. So on page 460 and 461, we have some interesting matters. It's all based around commentary of the Australian Solicitors' Conduct Rules. Clearly, Rule 3.1 is stressed. I just want to raise something in relation to undertakings, which is Rule 6.1. If a solicitor or a barrister provides an undertaking, then it is regarded as something which is very important and which must be fulfilled. So the flip side of that is that as a lawyer, you must be very careful not to give an undertaking unless you're confident that you can fulfill that obligation. So if, for example, in a court situation, I indicate to a court, a magistrate, for example, that I undertake to do something, then there are serious ramifications if I don't do that. So you've got to be careful sometimes to couch that language so that you have a bit of an out. And it might be that you undertake to exercise your best endeavours, for example, which means that if it doesn't actually happen for reasons that are outside your control, you haven't breached the undertaking which you gave to the court because you did exercise your best endeavours, as we say. Just be careful of this distinction, that is the undertaking of a solicitor versus the undertaking given by a solicitor on behalf of a client. It might be some fine lines, but there is an important distinction. So if, for example, in a conveyancing matter, I was to say, I undertake to pay the rates which are in arrears, then that means I, the solicitor, will be personally liable to fulfil that obligation. But if as a solicitor I say, I undertake on behalf of my client to pay the rates, and the rates are not paid, then the solicitor is not personally liable because the undertaking was given on behalf of the client and not personally. So if you're on the other side, just be careful about that. Rule 19.1, you must not deceive or knowingly or recklessly mislead a court. Rule 20.1, and you're right, Maria, it's a very interesting one. If you learn during a hearing that your client or a witness has lied to the court, falsified a document or suppressed material evidence, then you must advise the client that the court should be informed of the lie, request authority to inform the court, and refuse to take any further part in the case unless the client authorises you to do so. You must promptly inform the court of the lie, falsification, or suppression. So really what we're saying there is that you must correct that wrong. Now that is entirely different to the situation that I mentioned before about a prosecutor who doesn't provide the criminal history. And I know it's a fine line, but that's the way it is. An interesting question, and you'll be asked this a lot when people realise that you're studying law, is in criminal law, how do you go about acting for someone if they've said, I am guilty of the offence? Can you act in those circumstances? In short, the lawyer can act to defend a client even if they know that the client is guilty, but only to the extent where the lawyer can put the Crown to proof, as we say. Putting the Crown to proof simply means that you're asking the Crown prosecution to prove their case beyond all reasonable doubt. But you can't put up anything which you know to be wrong or misleading. And the principle behind that is that in our criminal justice system, everyone is presumed to be innocent unless it has been established beyond all reasonable doubt by prosecution that that is not the case. So you're entitled to see if prosecution can prove it. All right, any questions about anything that we've said so far? There's nothing on the chat facility. I can't see anybody waving their arms around as if they want to ask a question. So I'll move on, but if there are questions, please interrupt me or add it on to the chat facility.
Can I ask one, John?
Yes, thanks, Erin.
When you were speaking earlier about omitting to say things, what is the stance of the court if you admit to knowing a truth that hasn't come out? Is that still considered to be misleading? No,
not necessarily. So in the context, for example, of acting for a person in a criminal defence, the very good example I've given already is the fact that the person may have a criminal history and that wasn't disclosed. You don't have to disclose it. So there are similar circumstances like that where what might be regarded as a relevant truth is not presented to the court. In many instances, you're not required to disclose that when you're acting for the other party. Now, but you've got to be very careful. And I'll be careful only to give that one example for fear that I might inadvertently give you the wrong impression. But that's a good question. Thanks, Erin. Are there any other questions, comments? All right. So in the commentary, we've talked about the conflict between professional and personal views, and the comments by Parker and Evans on page 467, you might want to read quite carefully. Now, that brings us to the end of chapter 13. I'll just move into chapter 14, which is dealing with being globally minded. Probably from a practical perspective, there are two issues that you might come across. The first is the effect of the Hague Convention, which deals with family law issues, and the full title is The Hague Convention on the Civil Aspects of International Child Abduction. That comes from the Hague Convention conference, which was in 1980. It's referred to on page 473, and in practice, in those circumstances, you'll talk about it being a Hague Convention case in the family court. So that's one where you may actually get some real-life, practical international law which affects your domestic practice. Apart from that, the other area is in relation to international treaties. And the interesting thing is that international treaties and conventions are not automatically law, even if they are entered into by the Australian Parliament. It needs to be created in legislation and passed by Parliament domestically before the obligations which have been entered into from at an international perspective are binding on citizens in Australia. There has been commentary in the High Court, and this is referred to at page 479 of the text, where the fact that the executive government has agreed to sign an international treaty is enough to create a legitimate expectation that decision makers will comply with those obligations, even if not passed by law. The other thing that's interesting about that is that we're once again talking about the separation of powers, aren't we? So the function of entering into an international treaty was done by the government in its executive capacity. And what we're really saying there is that the mere fact that the executive government made or was a signatory to a treaty does not mean that it automatically becomes law, because that is a requirement or a right of Parliament as opposed to the executive. I hope I haven't confused you too much there. Please let me know if you need any further discussion about that. There are some interesting comments in relation to the different types of legal systems around the world. The common law system that we have is not the most common. The civil law legal system, which is adopted in many countries in Western Europe, is more common in terms of the number of countries, and you'll see that chart on pages 477 and 478 gives testimony to that fact. But we have the common law system, of course, which we've talked about. All right, so can the states legislate or enter into international law? In my view, that's a really good question, Aaron. I don't believe that states can enter into international law, but they can certainly legislate to deal with matters which are the subject of international law treaties. So, for example, in an environmental law capacity, many sections of the Sustainable Planning Act, which is a Queensland Act, do relate to international obligations, and they've formed part of the law in Queensland. But the state of Queensland, to my knowledge, is not able to be, or would not consider being, a signatory to an international treaty. There is the distinction between public international law and private international law. Private international law is sometimes known as conflict of laws, and that's a really interesting area in that if you're dealing with a company, for example, which is entering into a contract in Australia, but with a party that's based overseas, let's say China, if there's a dispute, private international law or conflict of law needs to be considered in the context of where that dispute is appropriately litigated, whether it's litigated in Australia or China, or whether there's the possibility of it being litigated in either jurisdiction. And then the question is, what happens if there is a conflict between the laws internationally in the context of that contract? Public international law deals more with those issues such as environmental law or immigration law, which are for the benefit of the public generally. And finally, in that chapter, to round off the book, is some commentary in relation to volunteering, and that's worth having a look at as well. All right, so that's a very brief overview of chapter 14, and that brings us pretty close to the end of what I wanted to cover tonight. Before we wrap it up, are there any questions or comments in relation to anything that's been covered tonight? Yes, Maria? I'm sorry, Erin. Was that you, Erin?
Yeah. The questions relating to the exercise where we had to look at all the various laws like contract law, environmental laws and things like that in terms of advising a client where international law is concerned. The last two I just had no idea how to answer, and that was to do with wills and estates and bankruptcy.
I'm not sure. I'm not sure I can remember that particular question. That's one of the exercises, is it, Erin?
Yes, it's the last. I think it's the last question for week 7. If I can get my textbook.
Yes.
Peter, have you got your textbook there? No.
Yes. Yeah. Do you remember what the question number was again?
No, it's the last question for week 7, Peter, where we had a list of different areas of law, and we had to, how would we advise a client with regards to international law in all those areas. There are about 10 or 11.
Yeah, okay, got it. 14.1 says, just make sure. Yep. Explain how an understanding of international law might be necessary in order to effectively advise or advocate on behalf of a client in relation to a matter involving each of the following. And your last two were bankruptcy and wills and estates.
Mm.
So like your bankruptcy and wills and estates, wouldn't that go into knowing, let's say for bankruptcy, wouldn't that be like international financial legislation?
Yeah, thanks, Peter. And I guess the circumstances might arise where a particular person is considering going into bankruptcy in circumstances where they owe debts domestically, but also internationally. And I guess one question that might come to mind is this. Let's say you're acting for a director of a company who is going bankrupt because he or she has been called upon to pay up debts which have been incurred as a result of giving a personal guarantee for the obligations of a company. And that company might be trading in Australia, China, Russia, United States. If that particular director declares bankruptcy in Australia, in Australian law, that would mean that all the debts are covered by the bankruptcy and no creditor is able to pursue those debts through court proceedings. The creditor in Russia, let's say, might say, well, I'm not bound by Australian law and you can't tell me that I can't chase my debts, so I'm going to chase the debts. So I guess that's, to my mind, an example of where bankruptcy might be made more difficult in relation to the context of international law. Does that sound reasonable to you, Erin?
I just thought it was a fairly difficult question for us to answer at this stage. That's all, not knowing anything about bankruptcy laws, let alone international law.
Yes. Oh, well, it's all there to test you, isn't it? And wills and estates, I guess you might have a situation where, a person signs a will in Australia, then signs another will overseas, or purports to revoke a will overseas that was made in Australia. The rules for revoking a will in Australia might call upon you to have a document which is signed and witnessed in front of 2 witnesses, whereas overseas it might be sufficient if there's 1. And in terms of estate law, you might have a situation where someone dies without a will. In Australia, though the rules are covered by intestacy laws, but those intestacy laws may not be consistent with laws overseas. So you have all these different situations, and because we're becoming much more of a global village, so to speak, this is going to be a growth area in terms of litigation, no doubt. But yep, I agree with you, Erin. They're pretty tough questions when you're first starting your law degree. All right. Maria was talking about child labour laws, and yeah, that's a really good example. Clothes made overseas using child labour. How is that regulated? There's only so far that the Australian laws can go. Another really interesting area is in terms of the internet, from a criminal law perspective, you know, accessing child exploitation material, etc., or trying to shut down websites which are sourced overseas. Very difficult for the Australian government to legislate, and even more difficult for the executive to intervene. So there are a whole lot of issues where international law can become relevant. So I think that's a really good question, problem 24, in terms of giving you an opportunity to think about these issues. All right, so I'm looking at the chat facility. I can't see anything there. Erin's just said, what happens to a child delivering papers and is hurt? Oh, that's a tough one, Erin. I'm not sure I guess it's a matter of the laws as they pertain in the place where the child was hurt would be relevant in those circumstances. Okay, so personal injuries law, says Josh. Yes, I agree with that. Thank you. Okay, well, that might bring us to a conclusion tonight. Can I just once again thank Michael? That was an excellent presentation, Michael. I really appreciated that. I would be lying to you if I didn't say that I learned something. I did. So, and what I learned was that part about now what was the actual term? It was putting things aside so that you could email them later on. And I've just forgotten the exact term, but
The delivery folder.
What was that? Sorry, Michael?
The delivery folder.
That's the one, the delivery folder. Thank you very much. So that was an excellent presentation and we really appreciate it. Okay, so we won't meet next week. We won't meet the week after that. We'll meet in 2 weeks tonight, which is the 7th of January, and we might start at 6 o'clock as a special time. So hopefully you can join us then, and if not, you can join us as we progress through the evening. I'll try and make it no more than an hour and a half though for that session. All right, well, I'll end the meeting now. I'll stop recording rather, and all the very best. Thank you.